There have been many changes to credit card regulations and laws, but problems remain. I'm Dan Ringer, and we'll talk about credit cards right now on the LawWorks.
From West Virginia Public Broadcasting.
The LawWorks is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
Credit cards have been and still are a problem for many people. My guests are West Virginia Deputy Attorney General Jill Miles and Derek Walker, Chief Investigator for the Attorney General's Office. Jill, Derek, welcome back.
Thank you, Dan.
Credit cards. I thought we fixed all this business with credit cards.
I tell you, credit cards have been a problem. For the last several decades, there has been very little regulation of national banks, which most credit card companies are affiliated with, and that is because of federal preemption. In other words, federal law prevails.
When there are state laws about something and federal laws about something, forget the state laws. The federal laws apply. It is said to preempt the field, that is to be the controlling law. You know, states can have laws about the same subject, but they can't be more stringent, and they can't be more stringent than the federal law. They can't control things that the federal government has chosen not to control.
Right. And unfortunately for us, for the consumer, the Office of the Comptroller of the Currency is the federal agency that has been mandated to regulate credit card companies or national banks. And they have not done a very good job. I mean, it really has been a battle for consumer advocates versus the credit card industry, basically a David versus Goliath. So let me put it in context for you, Dan. Let's say that you had a problem with your credit card. Let's say they raised your interest rate from 18 to 39%.
Which they can do.
Which they can do. You had absolutely no idea that they were going to do it. You'd always made your payments on time. You'd never gone over the limit. You file a complaint with my office. We handle consumer complaints. I can absolutely guarantee you we will take that complaint, we will mediate it, we will contact the credit card company, we will try to find out why they raised the interest rate, we will try to negotiate with them, but at the end of the day, they can thumb their nose at us because they do not have to comply with state law. And that's a problem. And it's very, very frustrating for state regulators because credit card companies have basically ran amok. We had a great thing that happened, in my opinion, that took place on May 22nd, 2009, and President Obama signed the Credit Card Accountability, Responsibility, and Disclosure Act of 2009. And that was the first time that there had been any major reforms of the credit card industry in 20, 30 years.
What were the reforms?
Well, the reforms have been absolutely sweeping, but in order to understand them, if I may, I'd like to give you a little bit of background about what was happening.
Sure.
Well, one thing that people are absolutely flummoxed about to learn is that there is absolutely no limit on the interest rate that a credit card company can charge you.
No limit at all?
No limit.
100% interest they can charge?
1,000, 2,000, it doesn't matter. The sky is the limit. The question is, how do we get to the point where we allowed credit card companies to become the loan sharks of the 21st century? And the way to explain that is to go back in time. Now, Dan, you were alive and well in the 70s. Derek, were you? I know, barely.
Barely.
When's your birthday?
I was alive, well, and fully mature
You were
by
alive,
the
well.
time the 70s came around.
What was the times like? Interest rates were high, unemployment was high, people were standing in line for gas, and banks were having to lend money because of usury caps, because limits on interest rates at a rate lower to consumers than they were able to get the money themselves. So what happened is there was a situation where there was a credit card company that was based in Nebraska. And the credit card company was soliciting people in Minnesota. And in Nebraska, the legal interest rate was 18%. You couldn't charge more than 18%. But in Minnesota, it was only 12%. And the Minnesota Attorney General's office said, hey, this isn't right. We have a state law.
The Nebraska bank was soliciting customers from Minnesota and charging them 18% interest on the money they loaned to them.
Exactly.
Instead of 12% as Minnesota law required.
Right. And so we're talking that preemption stuff, right? So the Minnesota Attorney General said, wait a minute, you can't charge more than 12%. That case, the case is Marquette National Bank of Minnesota versus First Omaha Service Corp of First Omaha Service Corp of Nebraska, went all the way to the United States Supreme Court. That was in 1978. And the Supreme Court held that a credit card company affiliated with the national bank can charge the interest rate that is allowable and legal in the state where they are located to anywhere in the country. So what happened next? South Dakota, they were really having hard times, right? So South Dakota eliminated the usury cap. The next thing that happened is Citibank was located in New York City. And the legal allowable interest rate in New York City was 12%. And Citibank was going broke. Citibank moves to South Dakota, can charge any interest rate they want. And the next state that followed was?
Delaware.
Delaware, right. So although this holding applied to all kinds of consumer loans, it had its greatest impact on credit card companies because those transactions occur through the mail.
What was the reason that the federal government said, if you know, you don't have to obey state law?
Well, I mean, this case was based on the National Bank Act, Section 85 of the National Bank Act, and they basically said that interest includes, the interest applies to in the National Bank Act, and it can apply to anywhere in the country. So they just said that federal law preempts and you can charge what you want.
All this is basically the same reason that West Virginia, for example, can't put up a toll booth at the state line and charge admission to West Virginia because that's violative of the Interstate Commerce Act. We also have national banking laws, and a state can't pass a law that is violative of the the national banking laws. So by some legal technicality.
Right. I mean, I think this actual unknown opinion has had an incredible impact on finance. I mean, it just changed the world for the credit card industry. One thing they started doing, they started raising the interest rate for any reason or no reason at all. And all they had to do was give you 15 days notice. And how was that notice? Where do you think that notice was?
Was it in very, very small print?
It was in very, very small print, included with your statement, hidden somewhere. The next thing they did is that they started raising your interest rate if a certain event occurred. So if you were late on making a payment or you went over your credit limit, your interest rate would go up automatically. Then the thing that I found very egregious is they put in your credit card holder what is called the Universal Default Clause. And what the Universal Default Clause allowed them to do is they could pull your credit report and they could look and determine whether or not you were a greater risk today than you were yesterday. So let's say, for example, you'd always made all your payments on your credit card, you'd never gone over the limit. But you had your car payment, you'd written a check for your car payment, put it on the dashboard of your car, and it got lost. So you were late, you didn't make the payment. That credit card company pulls your credit report, looks, and says, wait, Dan was late making his car payment. We don't care about how he dealt with us. We're going to raise the interest rate. And by the way, we can raise it whatever we want. The other thing they would do, let's say you decide, hey, I want to go out and buy a car. So you go out, you shop around, you go out and buy a $30,000 car, and you incur another $30,000 worth of debt. They go in, they pull your credit report. Wait a minute, Dan's $30,000 more in debt than he was yesterday. We're going to raise the interest rate on his credit card. So you get the idea.
So that's what it was before,
Right.
what was it, April or July?
Right. The actual bill was signed on May 22nd of 2010, and most of the provisions went into effect in February 22nd of 2010. I mean, it was signed May 22nd, 2009. Most of the provisions went into effect in February of 2010. So one of the things they did, one of the great things they did is they got rid of this universal default clause. They said you can't do it. They can only raise the interest rate on your credit card if they give you 45 days notice. Now, if you're late making a payment, 60 days or more, they can raise it. If the credit card, it was a promotional credit card and it's at the end of the promotional period, they can raise the interest rate. Or if it's a variable rate card, which is a card rate based on the prime rate, which is sort of confusing. So that was one of the things they did away with. One of the things they used to do, because of Marquette, I believe, is once Marquette became the law of the land and they could charge any interest rate that they wanted, they started marketing to people that they otherwise wouldn't have marketed to. And these are college students, kids who didn't have jobs. Now, I graduated in 1980. Marquette came down in 1978. When I was in college, nobody had a credit card. That just didn't happen. But once Marquette was passed, or was the Supreme Court ruled that way they did, the floodgates were open. And soon we had credit card companies on college campuses giving away T-shirts, giving away coffee mugs, giving away pizza, if they could get you to come up and sign a credit card application. And they started giving credit cards to kids that otherwise shouldn't have them. In 2009, Sallie Mae did a survey, and in that survey they found that 34% of all students come onto campus, freshmen, with a credit card. 84% have a credit card. The average debt is $3,100. 17% of them pay it off every month, and by the time they graduate, their average debt is $4,100. Now, what did the Credit Card Accountability, Responsibility, and Disclosure Act do? What it did is it said, credit card company, you can no longer sign up kids under the age of 21 unless they have a cosigner who's over the age of 21, or they can prove that they're independently, financially able to take care of the debt.
That would be tricky.
That would be tricky, and I have to be honest with you, I don't know the mechanics of how that would work.
Well, it sounds as though it was designed to be, and probably is, more trouble than it's worth for the credit card company.
Well, that's an interesting point. I hadn't thought about that.
Well, it probably designed to shut down the curbside sign-up for credit cards, because then what's the applicant going to do? Bring in his paycheck or her paycheck
Right.
stub and say, see, I'm making however much this is, because most college students aren't making very much,
Right.
even if they're over 18 or 21, as the case may be. Has it made a difference in the number of credit cards that are being passed off onto young people?
You know, I don't know the answer to that question. I can't imagine it hasn't.
I know the number of credit card solicitations that I personally get has dramatically dropped off in the past several months.
Really? Okay.
I used to get, in my home, I used to get 6 or 7, sometimes a day, from every bank conceivable. Now, I receive mail from myself, my wife, and my youngest son, but he is also over 21. But still, I'm not seeing a lot of credit card solicitations now. It may just be the economic times. I mean,
Right.
Banks are not interested in.
Well, the law also says that they're not supposed to send pre-screened credit card applications to people under 21. I don't know that I believe that's happening. You know, I don't know that I've seen that stopping. I do want to make one quick point about what you can do if you want those solicitations to stop. There's a number you can call, and it's 1-888-5-OPT-OUT, and it really works.
5 OPT
Right.
It means I have to translate the numbers on the keypad into letters, but
Well,
you can do that.
Probably, if I don't have the numbers memorized.
Okay, again, that's 888-5-OPTOUT,
Right.
opt out.
You can do that online and it will stop, or you can call them up, obviously. I don't have the website memorized, but you can go online and it will stop for 5 years, and then if you want it to stop forever, they'll send you something. You have to fill out a piece of paper.
Okay. Well, that's very handy. In fact, I bet that's available through your website at the Attorney General's office.
It is.
It's wvago.gov. It's West Virginia Attorney General Office.gov. What's the future hold for all this? Where are we going?
Well, and I mean, I think that I think that credit card companies needed to be rounded in, and they needed to be reined in. I think things were going out of control.
We're talking about credit card problems. My guests are West Virginia Attorney General Deputy Attorney General Jill Miles and Derek Walker, Chief Investigator for the West Virginia Attorney General's Office. This is the LawWorks. I'm Dan Ringer. We have to have credit cards. I mean, we've talked in other shows about the problems of negotiating checks and things like that. People making extravagant demands or suggesting weird schemes, using checks and every other method of fraud conceivable. Credit cards do come with some great protections. What kind of protections do credit cards come with?
Consumer protections with credit cards are greater than with any other method of payment. Our office suggests folks, if you're going to happen to be an online shopper, a lot of people are still leery of shopping online, but every day more and more people jump on the internet to make purchases, especially holidays are coming up and people can find great deals. If you use your credit card, you've got consumer protections that you don't have from any other method of payment. If you use your credit card and the number gets stolen, for example, and someone uses that number to make purchases on your account, you're not responsible for those purchases. If you report it to your credit card company that your number's been compromised and you have unauthorized transactions, the most a card company may charge you is $50. But most credit card companies don't even charge those fees at this time.
Sometimes those are waived.
Right.
And I had a situation where I lost a credit card when I was on vacation a few years ago. I didn't realize I'd lost it. My bank looked at the purchases that were being made and compared that with my credit history. It's probably a computer routine somehow. But they called me and said, "Do you have your credit card?" I checked. I said, "No, I don't." They said, "Your card's been compromised, stolen or changed." I not only didn't have to pay the $50, they promptly issued me a new credit card. I don't know that they ever caught the people or person who did it, but it was remarkable. I didn't have to lift a finger. And I certainly had good feelings about that company after that, and I still have one of their credit cards, because it just seems like, A, that kind of service is rare,
Right.
and B, that is very helpful and very protective. Of course, it's in their best interest too, because they just have to eat those charges. Nobody's going to get the tennis shoes that the person bought, the cell phone that the person bought back. I mean, that's just gone.
Right.
But the bank's okay. So not all bankers are evil. There's a tendency to think that big bankers must be up to something, but that's not always true.
I think that maybe, what are the rules as opposed with debit cards, Derek? I mean, I know a lot of I have 17-year-old twins, and the debit card is like cash to them. They use it all the time.
And never-ending cash.
Never ending, and there are things that happen with the new Credit Card Act that I'm thankful for also. But does the same rule apply? Is it?
The debit card rules and the credit card rules are very different. The debit card rules are more complex. A simple way to explain the debit card rules is let's say you use your debit card and you happen to lose it. Like you mentioned when you went on vacation, if you'd lost that debit card and someone went out spending with that debit card and you hadn't noticed it for several days, more than likely your bank's not going to call and say, "Hey, somebody's using your debit card," like the credit card company did, because your debit card, it's your money. It's not the bank's money. But if the person uses that debit card and you happen to not notice it for 3, 4, 5 days, you can be responsible for $50. You're going to be responsible for that $50. If 60 days passes and you haven't reconciled your bank account and called your bank and said, hey, somebody's using my debit card unauthorized, the bank can, the sky's the limit. Whatever they've charged, you may not ever get that money back.
So it's incumbent upon you to protect yourself totally with the debit card and timely.
Correct. And the time, there's a 2-day limit for like $50. You have between 2 and 60 days to report it, and you're responsible for $500. If that 60-day threshold exceeds whatever they've taken, the bank's not required to give it back to you.
I've got to admit, there have been times when I got busy and I would sit down finally after 3 or 4 months with a stack of reconciliation statements from my bank and start through them, and I would find things that I had questions about. But if I had waited 3 or 4 months and there was hinky debit card activity, I would be stuck with it when I finally realized this had gone bad. We're talking about credit card problems. My guests are West Virginia Deputy Attorney General Jill Miles and Derek Walker, the Chief Investigator for the West Virginia Attorney General's Office. I'm Dan Ringer, and this is The Law Works. I hear ads all the time on television for companies who are going to deal with the credit card companies and save me thousands of dollars, and I might not have to pay anything. You both shook your heads when I started talking about that.
Right.
What's wrong with that picture?
Well, what's wrong with that picture is these companies are they're called what are called debt settlement companies, and they're usually on late night TV. And when
I'm awake worrying about my debts.
Right, when you're worrying about your debts, and they'll say, are you more than $10,000 in debt? If you are, stop paying your credit card companies and pay us instead. And typically what they will ask you to do is to make a large upfront fee, $2,000, $3,000, $4,000, and then they will ask you to make a payment into an account and to also pay an administrative fee. Stop paying your credit card companies. The theory being that that account that you've paid into will at some point build up to a certain amount where they can contact your credit card companies and try to negotiate the debt down. We have sued lots of debt settlement companies. They're all over the board in terms of what they do and do not do. I would say most of them do nothing. Absolutely nothing. And there's a series of, we make a lot of arguments as to why they're unlawful. They're not registered as a credit service organization. We think they're extending credit. They are engaged in the unauthorized practice of law, which I think is a novel theory that we've come up with. But
well, they say they've got attorneys on staff who not so much.
Well, that has not been, we have not found that to be the case.
The novel twist on this that I have heard of late is that if you owe more than a certain amount, maybe $10,000, the law provides you have an absolute right to pay less than you owe and to have the debt discharged. Where does that come from?
I don't know. I think people think that comes from the IRS code. We have some cases dealing with that as well, but I don't think that's the case.
I suppose this all falls under the, or falls in the envelope of there is no free lunch.
Right.
Credit card companies, banks, no government is going to allow you to go out and purchase thousands and thousands of dollars worth of goods and services and then say, oh, well, you don't have to pay for that.
Having said that, Dan, and I agree with you totally, credit card companies will negotiate. And if you're in a situation where you have a large debt and you're not going to be able to pay it off, I have been successful in getting credit card companies to agree to accept the principal amount that you owed.
And suspend the interest.
And suspend the interest and the late fees. I've been able to get them to do that. Now, there's no guarantee because, of course, I don't regulate them.
Well, and you're the Attorney General's office, too, and you get their attention. In fact, dealing with an attorney perhaps can get some things like that done also, but you don't need to hire some third-party out-of-state entity. Just send Jill your money. It'll have the same effect, and it'll make Jill happy.
Right. Did I mention there is a fee? No, I'm too. Actually,
No, you do not do that.
Absolutely free.
That's right. The Attorney General's Office of Consumer Protection Division does a lot of good things. We might refer you to the Attorney General's website. It's wvago.gov, wvago.gov. There is a tremendous amount of information there about a number of things, particularly about consumer protection. Jill Miles, Derek Walker, thank you folks for being with us.
Thanks again, Dan.
Thank you also for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks program topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find a video of the program at the LawWorks website. You'll also find free video and podcasts of previous programs on YouTube and iTunes. If you would like to suggest a topic for a future program, or if you're a school teacher and would like to receive a free copy of this show for classroom use, send us an email to thelawworks@comcast.net.
The LawWorks is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The LawWorks is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.